Hello, my name is Danielle Cohen and I'm an immigration and human rights lawyer with over 20 years experience. I have established my own firm, which is based in Camden Town, London, and we are a unique niche immigration and human rights firm specializes in that area of the law. Today I would like to discuss with you a subject that is particularly close to my heart, which is the adult dependent relative route. We work extensively in this area with people from all walks of life, and in order to start the discussion, we need to compare the situation to before 2012 and after 2012. Before 2012, a settled or British person could bring their adult relatives to live with them in the UK. After 2012, the government introduced the adult dependent relative route, which is a very difficult route to satisfy, and very few applications are successful. If the application is successful, your relative will obtain indefinite leave to enter. What are the evidential requirements? In order to succeed in an application, you have to demonstrate that your relative, as a result of illness, age or disability, requires long-term care to perform everyday tasks, and that this care cannot be provided to him or her in the country of origin, even with your financial support. To be able to demonstrate that there is no availability of care, the test is not whether it's available, but whether it's suitable and accessible for the person who needs it. The best way to be able to succeed in a case like that is to use the holistic approach that I practice in my firm. You will have to demonstrate the lack of available adequate care. You will have to get assessment of the medical needs of your relative, and preferably a country expert report to demonstrate whether or not this care is available, adequate, especially post-COVID. We deal a lot with cases from Pakistan and India, and we know that the COVID pandemic affected the health system in these countries dramatically. It is also useful for the country expert to comment about stigma, the idea that society has about care within the family unit, and to have the applicant assessed physically and psychologically as to their other needs, which might not be only physical. Once you have obtained the information that you need, which is medical, country information, you will have to demonstrate that you have the adequate maintenance and accommodation to be able to support them. Please note, there is no specific financial threshold. You have to meet the test of adequacy. It is also useful to show why you, the sponsor, cannot assist them, why you cannot relocate. And we have won in quite a few cases when we demonstrated that it is not to be expected that the sponsor will abandon their life in the UK in order to help the family they left behind when they came to live here. In short, the evidence that you will require is physical, mental, financial, and country information. We have noticed recently that the Home Office and judges suggest that care homes might be the solution. We don't accept that assertion. Care homes sometimes do not provide adequate care and do not take into account the wishes or the needs of the applicant involved. Each case must be decided on its fact, and it is with great pride that I can say that in my firm we look at each case individually to provide a more specific resolution. What leave would my father or mother get? Your parents will obtain indefinite leave to enter the UK and will have access to the NHS. What if my application is refused? If the application is refused, you will have a right of appeal. You will have to exercise this right of appeal within 28 days. Please note, it is different to the timeline if an appeal is brought in country.